Chapter 10, Consideration, presented by Kelly Herzick. In Chapter 10, we're going to cover three main areas. This is a relatively short chapter, but consideration permeates contract law. We're going to cover the definition of consideration, the rules of consideration and their exceptions, and partial payment of a debt and how that affects consideration. Let's begin with the definition of consideration. To be legally binding, a contract must have adequate consideration. We've discussed offer, acceptance, and mutuality, but without consideration, there is no contract. Consideration is what a person will receive in return for performing a contract obligation. It is the benefit that must be bargained for by the parties. It is essentially the reason that a party enters into a contract. Consideration can usually be anything as long as it is bargained for. In business, the consideration is most often money. Here are examples of consideration and the kinds. This is also available in Exhibit 10-1 in your book, but examples of consideration are a benefit to the promisor, such as agreeing to stay in a job for a set time, a detriment to the promisee, such as refraining from doing high-risk sports during the semester, a promise to actually do something, such as a promise to clean the house for 6 months, or a promise to refrain from doing something, such as a promise to stop smoking during pregnancy. As you can see from Exhibit 10-1 in your book and from the previous slide, consideration seems to be grouped into two types, either a detriment or benefit to one party, or just a pure exchange of something for something that's bargained for. And that's because there are two different theories of consideration out there in the law: benefit detriment theory of consideration and bargain for exchange theory of consideration. They seem similar, but they have one key difference. Benefit detriment theory means that adequate consideration exists only when a promise is made to the benefit of the promisor or to the detriment of the promisee, which reasonably induces the promisor to make a promise for something else for the promisee. It basically means that for there to be consideration, somebody has to give up something. I would want to note that promises that are purely gifts are not considered enforceable because the personal satisfaction of the grantor of the promise that they can get because they've been generous is not adequate consideration. The general rule which you need to know is that gifts are usually not adequate consideration. Now, in bargain for exchange theory of consideration, adequate consideration exists when a promisor makes a promise in return for something else. There doesn't have to be a detriment to one of the party. There just has to be a bargain for exchange. It can even be what they call a win-win. Here, the essential condition is that the promisor was given something specifically to induce the promise being made. In other words, the focus in bargain for exchange theory seems to be the party's motive for making the promises and the party's subjective mutual intent. While in detriment benefit theory, the focus seems to be an objective legal detriment or benefit to the parties. Really, these are very close, and it just has to do with whether or not there needs to be a detriment as opposed to just a bargain for exchange. What you need to know for testing purposes is that there are two types and what they are, and what they generally do. Now let's discuss the rules of consideration. The key to understanding consideration and doing well in the test is to understand the rules that govern it and the exceptions to those rules. The main rules of consideration are lack of consideration, promissory estoppel, adequacy of consideration, illusory promise, past consideration, pre-existing. Let's talk about lack of consideration, which is the first rule of consideration. For a promise to be legally enforceable, there must be consideration. That's the bottom line. Consideration is the key to contract formation. You can have an offer and acceptance, but if there's no consideration, there is a lack of consideration, a contract will not be enforced. This is sometimes known as legal sufficiency of consideration. Courts will only enforce a party's promise if the other party promised something, such as a money or an act, in exchange for the promise. That is what consideration is. Now, we've talked about bilateral contracts. In bilateral contracts, the consideration is a promise for a promise. Let's examine an example. It's a written contract for the sale of land, because those have to be in writing under the statute of frauds. Betty promises to pay Larry $150,000 for his house, with the sale to close within 60 days. The return promise is that Larry promises to sell the house for that price as long as the sale closes within the 60-day time period. You can see the exchange. It's a promise for a promise. I promise to sell. I promise to buy. In unilateral contracts, the consideration is not a promise for a promise. It is a promise in exchange for an act. That's the lost dog example. Larry offers a reward of $100 for the safe return of his lost dog. Betty finds the dog and brings her to Larry. The consideration to Betty is the promise to pay money for the return of the dog, but the consideration to Larry is Betty's act of returning the dog safely to Larry. Remember, ultimately, there has to be a mutual exchange of something of value. It doesn't have to be money, but it cannot be worthless. Next, we're going to talk about an important equitable concept called promissory estoppel. It's somewhat difficult to understand, so we're going to walk through it, and then I have a fairly lengthy example so that you can understand how it works, because you will see it again. An exception to the requirement of consideration, a promise for a promise or a promise for an act, is the doctrine of promissory estoppel. Promissory estoppel is the legal enforcement of an otherwise unenforceable contract due to a party's detrimental reliance on the contract. Courts use the principles in equity or fairness to ensure that an innocent party that relied on a contract is protected. Modern courts sit in both law and equity. They interpret the law, but they can also apply equitable principles to protect innocent parties who are unfairly disadvantaged in contract. Courts will find promissory estoppel applies when one party makes a promise knowing that the other party will rely on it. The other party does reasonably rely on the promise to his detriment. That has two parts: reasonable reliance on the promise and a move toward your detriment, meaning you have to change position. And the only way to avoid an injustice is to enforce the promise. This is also known as unconscionability in some states. And it's really just ultimately a fairness issue. Courts in equity will look at whether the parties are acting in good faith towards each other. In every contract, written contract, whether it's long or short, there is an implied duty of good faith and fair dealing. And courts will enforce that when parties don't act in good faith towards each other with respect to any term in the contract. Courts are really just looking at, are parties treating each other fairly? There are two classic examples where this comes into play. One is a verbal promise to rent a house for more than a year, or a verbal promise to sell property. Both these verbal promises run afoul of the statute of frauds because they both have to be in writing. The rental agreement because it's more than a year, and the verbal promise to sell a house because it concerns the sale of real estate. But if a person reasonably relies on either of these promises to their detriment, the contract, though verbal, can be enforced. Now let's walk through our promissory estoppel example. Suppose Larry is a real estate flipper and has several houses for sale. Bob wants to buy one of Larry's houses and goes to see him at his office. After they look at Larry's portfolio of houses, Bob sees one he likes. Larry verbally offers to sell Bob his house on Baker Street for $100,000 as long as Bob pays the monetary consideration and closes the deal in 30 days. On its face, this would be a valid contract because all the terms are sufficiently clear. However, without more, this verbal contract is unenforceable in law because it violates the statute of frauds that requires a writing for a contract for the sale of land. So without any more facts, if this is all the facts you have, Bob cannot enforce it under these circumstances. But what happened if Bob reasonably relies on this verbal offer? In this situation, Bob's reliance on the verbal offer is probably objectively reasonable. That's the standard. Most people would think that it would be reasonable in these circumstances for Bob to rely on the offer that Larry gave him, given the discussion is at Larry's place of business and the offer is specific with all the material terms stated. The average person doesn't know what the statute of frauds is. It would also be reasonable to infer that Larry made the offer knowing that Bob would rely on it because they're in his office, it's a business situation, and they're actually discussing the sale of this property. But that might not help Bob if the circumstances change. Suppose they're at a cocktail party and Larry says, I have a lot of houses for sale, and I have this one I could sell you for $100,000. You ought to take a look at my website. It sounds like Bob is getting an offer from Larry to sell a house for $100,000, but not really. This is really an illusory offer, and it would not be reasonable for Bob to rely on it in the circumstances, because this is a reasonable reliance and it has to be reasonable given the circumstances where the offer is made. Remember that promissory estoppel, the second element, has two elements: reasonable reliance and a change in position, a reliance to your detriment. Reasonable reliance on its own is not enough to make a contract unenforceable in law, enforceable in equity. For promissory estoppel to apply, in addition to reasonable reliance, the party must in fact rely on the promise to his detriment. So what does that mean? This means that the party relying on the offer has to materially change his position in reliance on the offer. Assume Bob relies on Larry's verbal offer to sell him the Baker Street house, but does nothing else. He is not in any worse position according to the law, so promissory estoppel won't operate in equity to enforce Larry's promise. In other words, if Bob just relies on it and thinks he has an offer in his back pocket, but does nothing else, he's not going to win in court. On the other hand, if Bob relies on the offer and sells his current house to raise the money or takes out a loan to get the cash, he has changed his position to his detriment. If Larry then refuses to sell the house to Bob, the law will not allow Larry to defend against Bob's lawsuit to enforce the sale by arguing the defense in law of the statute of frauds. In equity, Larry is stopped from arguing that the contract is only verbal and not enforceable due to Bob's reasonable reliance and change in position to his detriment. Basically, the court is looking at the fact that this was an injustice. Bob went out, sold his house, is homeless, and now has no place to go because of Larry's offer. And so Bob reasonably relied to his detriment, and the court is going to use promissory estoppel to protect Bob. The next rule of consideration is known as adequacy of consideration. Courts usually do not look at the adequacy of consideration, meaning the court will not weigh into whether a party has made a good deal or a bad deal. Without more, a court will not set aside a contract where one party overpaid for a product or service. If you overpay for a used car, that's on you. Parties are presumed under the law to do their reasonable due diligence prior to entering into commercial transactions. In other words, you should have got on Car Guru and looked at the prices to see if you were getting a good deal in that used car or not. However, the consideration paid must not be unconscionable. You probably remember the word unconscionability in our discussion from promissory estoppel. Overarching fairness, unconscionability still governs even in adequacy of consideration. Otherwise, if the consideration paid is unconscionable, if someone is taken extreme advantage of, then equity may come into play. This is where consumer protection laws most often apply. You can't take advantage of someone who's starving and charge them $100,000 for a candy bar. Consideration can sometimes be nominal, or is known as consideration in name only, like $5 for a $50,000 car. The general rule is that a contract with nominal consideration is not enforceable. There's a lot of exceptions, but I'm going to be testing primarily on the general rule this time. It can still be adequate based on the terms of the contract and the circumstances, like in a deed for real estate. When the parties want to obscure the value, they may say $10 and other good and adequate consideration for a $100,000 property. It might also be acceptable in the transfer of real property between family members, but it just can't be a sham or pretense. That's what you really need to know about nominal consideration, is that it's generally not enforceable and it can't be a sham or pretense. The next rule of consideration is called pre-existing duty. A promise to do something that you're already obligated to do is not valid consideration. That's the general rule under the common law. This usually impacts contract modifications, particularly in the construction industry. The rule has two parts. One, either the performance of a duty you are obligated to do under the law is not good consideration, or performance of an existing contractual duty is not good consideration. There's great examples of both of these in your book on page 209. There are exceptions to the pre-existing duty rule. Unforeseen circumstances is the most common. If an unforeseen circumstances causes a party to make a promise regarding an unfinished project, that promise is valid consideration. Unexpected sinkholes in construction, hidden defects in a home remodel, huge rocks in the backyard when you're digging a pool. These can all justify asking for more money on the project because it's unforeseen that these events would happen and those cost more money to take care of. Then there is additional work. A party agrees to do additional work not in the original contract. That's different from unforeseen circumstances. Additional work is like when you're asked to build a house and then later on the person you're in a contract with comes to you and says, I need you to build a shed in the backyard. Well, you didn't contract to build the shed, and so it's perfectly acceptable to ask for additional money to build the shed. And if the person agrees, that's a binding contract. Then there is the UCC, the sale of goods, which we'll talk about in a later lesson. The UCC has substantially altered the pre-existing duty rule. Under Article 2, modification of sales contracts does not require new consideration, but all modifications must be made in good faith and without intentional deceit. We'll talk about this later and why this rule has changed and why that it's important. The last consideration concept we're going to discuss is partial payment of a debt and whether that can serve as consideration for a contract. Unfortunately, partial payment of the debt may or may not be sufficient consideration for an enforceable contract. There's no general rule that can be simply stated here. You'll actually have to look at the facts. It's dependent on whether the debt is liquidated or unliquidated. You have to look at the type of debt. A liquidated debt is one that is known. There's no dispute that the money is owed, or there's no dispute about the amount due. You know that your credit card bill is $500, and that means that nobody else has been using your credit card but you. You know how much you owe. That's a liquidated debt. If the debt is liquidated, a creditor's promise to accept less than the amount owed when the debtor is legally obligated to pay the full amount is not binding. Now there is an exception to this rule, and it's called accord and satisfaction. Accord and satisfaction is a term of art, but it means that if the debtor offers a different performance, such as surrendering property in lieu of a monetary debt, and the creditor accepts, the debt is discharged. An example of this is offering to tender a piece of property in lieu of a monetary debt. When foreclosures were very high in this country, a lot of borrowers wanted to do something called a deed in lieu of foreclosure. They wanted to deed back their house to the person who owned the lien, the bank, in lieu of having their house foreclosed upon. They would transfer the title of the house back to the bank, and if the bank accepted that property back, the house as a deed in lieu of foreclosure would discharge the monetary debt. Unliquidated debt has different rules. So what is unliquidated debt? Unliquidated debt is a debt that is disputed, either in the amount due or even whether any money is owed at all. If a debt is disputed, the parties can settle the debt for less if the parties enter into an accord and satisfaction. Unlike liquidated debt, that can include the payment of less money in exchange for the release of debt. For an accord and satisfaction to be enforceable, the debt must be liquidated, disputed. The creditor agrees to accept less than what the creditor believes is owed. And 3, the debtor pays the reduced amount agreed on. An accord and satisfaction is an arrangement between contracting parties whereby one party substitutes a different performance for his or her duties under the original contract. When it comes to the partial payment of a debt, if the amount is liquidated, in other words, you know what you owe, you can't substitute money for money. You can substitute property for money or some other different performance, but that substitution of money for money isn't binding on the creditor. If the debt is disputed and it's unliquidated, then the substitution of a lesser amount of money for a higher amount of money is binding. But the promise to perform the new duty is the accord, and the actual performance of that new duty is the satisfaction. This is very important because if the debtor does not pay the reduced amount as agreed, the creditor can sue on the original debt amount. On the other hand, if the debtor does pay the new amount, the full debt is discharged. Basically, it pays to honor your promises. Before we close out this section, I briefly want to talk about accord and satisfaction and how the UCC has impacted this traditional rule. Under traditional common law in many states, people would try to create an accord and satisfaction on a debt by writing paid in full on a check and sending it in. If the check was cashed, the creditor had to accept the smaller amount as payment in full. This was seen as manifestly unfair, particularly for large banks that may have thousands of checks, mortgage checks that come through. They can't be expected to scrutinize the face of every check looking for paid in full language. The UCC changed the scope of this rule. Under the UCC, Section 3-311, this is passed in about 30 states, the rule remains in place but has 2 major exceptions. Businesses can direct debtors to send any conditional payments or any offer to settle a debt for less to a specific address, meaning that you can't just send this type of check to the regular payment box and hope it slips by. You actually have to send it to a specific location that the creditor tells you to send it to. This helps businesses from inadvertently creating an accord and satisfaction by cashing the check. And if a business does inadvertently cash a check with paid in full language, the business has 90 days from the day to cash the check to offer to repay the amount sent in by the debtor. If the business makes the offer to repay the debtor, no accord and satisfaction exists. This is the end of Chapter 10.